It's not unusual for you to have someone whose judgment you trust regarding lots of very personal things, but that person doesn't have the sort of business judgment. And maybe you'll want to say, fine, I'll have somebody who will be in charge more of the asset decisions and someone else who will be charged with more of the distribution decisions. When you're deciding who's going to run it, who's going to follow the instructions, you have a lot of options.
Yeah, I tell our clients very often, if you think it can think it up, I can write it.
Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
Welcome to another episode of Life's Third Act. This week we're going to deviate a little bit from our standard subject matter in the sense that we like to really focus on celebrities, to focus on circumstances where we can learn from the mistake of others. And we find that it's more interesting to learn about famous people whose mistakes and missteps and whatnot may be a learning opportunity for us. So that's what we often do on this show. But at the end of the day, Life's Third Act is about equipping you to better plan for the last third of your life. So whatever we do in this show is intended to be beneficial to you in that way. In some ways, it's more direct than others, but there should always be that benefit. But we also want to do it in a context of this show being interesting. There's lots of boring stuff out there, and you want to find things that you can actually be engaged in and at the same time learn something. So today, we did an interesting thing. We had our research staff, which essentially is comprised in the person of Justin. Justin?
I'm the sole research staff.
Yeah. I'm tempted to refer to him in the plural, but we'll say that he's a man of many talents. And so the research that he did was to see what are the most common questions that people have online about estate planning issues. What are the things that worry them, that they feel this sense of urgency about? And we focus specifically on looking at YouTube, and by whatever means he used, he calculated what are the questions that are most pressing for more people relating to estate and last of life issues. So that's what we want to touch on today. And with us, although you've seen on this show before a few times, John Sauter. John, welcome back.
Thanks, Joe.
John is a leader in the estate planning group of Cordell Cordell. So he's really the perfect one for us to sort of walk through this with and talk about these questions that we've assembled here. And Justin has found 8 questions that I'm willing to bet the majority of which will be of interest to you, questions that you yourself have. Maybe all 8, but certainly hang around to go through the list because our research shows that there's a good chance that most of these answers and these questions will be relevant to you. So we'll start out, John, with what is the difference between a will and a trust?
That's a great question, Joe. And I can understand why people want to know what this is. I think you have to start this with what is a trust, right? Because I think that's one of the most confusing estate planning documents to people because they really don't have a concept to attach it to, right?
And it's a difficult thing to explain.
It is, because it's an agreement, right, between you and yourself. And if you're not an attorney, at agreement, you might get lost, right? What is going to be in that agreement? When I talk to our clients at Cordell about this, I explain it as it's an empty box with a set of instructions on the lid, okay?
That's a good way to think about it.
You're creating an entity that's outside of yourself that's going to hold your property, right? And when you're creating that box, there's essentially 3 different characters involved, okay? There's the settlor, which used to be called the grantor, okay? That's the person that creates the box, puts their stuff in it, and writes the instructions that are going to be on the lid, okay? Mm-hmm. Then there's the trustee, okay? That's the person that's in charge of holding the box and following those instructions that are written by the settlor.
And protecting what's in the box.
Definitely protecting what's in the box. And then we've got the beneficiary. Who is this all being done for, right? And so those are the 3 people that are involved in creating a trust.
That's a good way to think about that. I hadn't heard it put that way before, but as a box.
Mm-hmm.
Yeah. And then explain too, there are layers, meaning that we start out with one settlor, maybe two settlors, typically one. And you have to plan for the possibility that you could have turnover among your trustees and your beneficiaries. In other words, trustees sometimes quit. In other words, someone you've placed in charge of taking care of your stuff for, say, if you had minor children, or if you were to become incompetent. You may be such a headache that the trustee decides to quit. So for various reasons, sometimes trustees die. And if this box is to continue, if your instructions are to go into decades, and often we will recommend that our clients do that, then you can expect some turnover. So you can have a change of trustee and you can have a change of beneficiary for the same reason. Beneficiaries die, and then you may want to provide for that next generation, or you may not have even anticipated that somebody could have died before you did, or some other change has taken place where you want to have someone standing in line. So how do you often explain that concept?
Yeah, you've hit a lot of the big issues, right? And a lot of that comes from one single problem, is we can't predict the future, right? No one has a crystal ball. And so when we're looking at planning, we're talking about what's going to happen in 10, 20, hopefully 30, 40 years, right? And if I talk to my clients and I bring this up, I'll say to them, I want you to think back 20 years, right? Give me 20 years younger Joe Cordell, and I'm going to go up and talk to him and say, where are you going to be on December 16th, 2025, right? What's going to be going on in your life? Who's going to be important to you? What are you going to be doing? How good would you have been at predicting that?
Ah, man. Well, the best laid plans.
Right.
Not that I would have been disappointed to hear I'd be sitting here with you, but there's something about the hope of a beach in southern France that might have come up in that scenario.
I don't think you're alone in that being the dream.
But I can't complain, you know. So I think the best we can do is hope for broad outlines.
Yeah, and I think that's a big thing people get confused about trust. They come in and they're ready to say, okay, where do I list all my stuff, right? And it's not really that way. We're going to write a loose outline of what we hope to happen. But the beauty of a trust is really in the flexibility, right? Because I can sit down with you and I can say, ideally, you want this person to manage your property. You want them to do it this particular way and for the benefit of these people. Okay. Now you've already created 3 factors that could change on you.
Yeah. Yeah.
And it's my job to go, okay, great. Sounds like a great plan. But what happens if this happens? What happens if this person's not available? What happens if that person's not available, but maybe something's going on in their life? It just doesn't make sense for them to take on this task because it's a lot of work. And that's how we get to write into a trust. Here's my first choice for my successor trustee, but here's my second and my third.
Yeah.
Right. And what that does is I tell people, don't think it's so much about picking as about giving opportunity, right? Here are the 3 best people I think that could do this job. I trust them enough for them to make the best decision in the future about who should do it.
And we should probably also mention that people can actually empower someone to make that selection for them in the future. In other words, it's not uncommon for maybe you're in a situation where you don't know who that would be. Maybe you have one person you can think of, but when it comes to something happening with that person, you think, there's no one else in my life. Well, the good news is you can empower a third party to make the selection for you. You can even have the outgoing successor trustee, if they have the ability, depend on the circumstances that cause the turnover. If it's sudden death, then you don't have that. But often you can have somebody who may be resigning because of health, and they would be in a position to pick that. So if you trust that trustee, sometimes you can give the power that way.
Yeah, and sometimes you might be limited by your circumstances, right? I speak to plenty of people that can pick 2 or 3 people, but for some people that's a heavy lift, right? Is how many people do I have in my life that I'd really trust with this?
Some people struggle
Yeah.
for one person that they trust. If that's your family, you have our sympathies. But it's not unusual, incidentally, to be in that situation. And in fact, sometimes people don't choose family members at all, in part because of the potential for conflict.
Correct.
I mean, they are, in the legal sense of the word, we use the word interested, meaning that they're not objective because they have a personal stake in the decision one way or another regarding any given thing. So it's not unusual, but that let me be quick to add that doesn't disqualify your trustee, because it's often the trustee is one of the children,
Yep.
or or somebody who is also a beneficiary. That's not unusual. So it doesn't mean that it's a problem when there's a potential conflict.
Yeah, conflict, right? That's a question that comes up a lot. I want to avoid conflict, and I'll have a lot of sweet mothers who want to be fair, who will say,
Oh,
"Well,
my gosh.
we'll just put all of them in charge," right?
I know. That is more common than I think those of you watching. You're not in the majority who would hold this opinion, but it's not uncommon to have exactly what you say, where the parent is very concerned about how this is going to look or feel to the child that's not empowered or included as trustee. But let me tell you, that sort of egalitarian approach can come with a massive price.
It can. And there's a couple reasons why. First off, when you put everybody in charge, no one's in charge, right? Because it's not clear who has the authority. Okay. And it's not just not clear to the three people you've named. It's not clear to anybody they're trying to manage your property that those people are the custodian of. They go to the bank and it says three names on there. Most likely, regardless if I write in there that only one can act, they'll want all three signatures every time.
Yeah.
And that can be a real hardship on an already difficult job.
Yeah. And if you say, well, the reason I'll avoid these conflicting decisions is I will require unanimity among the three, for example, that creates a very probable scenario in which there's a deadlock. And it's a deadlock often regarding things that are very urgent. So that we're really talking about the trust here. So I'll just make a parenthetical comment that this applies with exclamation marks regarding decisions of health care. Someday we'll do, I don't think it's on our list here, but we'll talk about durable power of attorneys. We've talked about it before, so you can find those episodes. That, health care directives, those things that will relate to your care at the very end of your life. You don't want three people having to agree, because there's a good chance that nothing will be decided, and which means going to court.
Mm-hmm.
It means it ends up in front of a judge. The very thing that motivated much of this planning was to avoid having a judge do this and everybody in the courtroom being paid out of your account to be there. You really don't want to set up a scenario that's going to invite that complication.
Yeah. And I'll have plenty of well-intentioned parents tell me, my kids get along great. They haven't had any issues in years. And I'll say to them, that's amazing. Did they ever fight as kids? Oh, yeah, like cats and dogs, right? Well, they don't live together now, right?
and they're not competing for the same thing anymore as they were for kids. And, now it's, at the risk of sounding crass, it's money.
Mm-hmm.
And money makes people do things and brings out the worst. It brings in wives, husbands, meaning in-laws. I mean, it brings other people into the discussion, and they consider it their business too, which technically I guess it kind of is. It's the couple. So you could definitely end up with conflict with kids, and you don't have to be a lawyer to know this. Some of you are nodding your head, yep, I knew so-and-so that went through this.
Yeah.
So you don't want to build that in. So when you're choosing a trustee, there are sometimes reasons to have a couple, but generally speaking, it's better to not go above two. I think that's a safe statement to make.
That's a really safe statement. I prefer one. I do agree there's situations where two makes sense, especially if there's specific property in there that requires a specific talent. Right.
Expertise. Mm-hmm. That's a very common scenario. We should mention that. It's not unusual for you to have someone whose judgment you trust regarding lots of very personal things that are relational, things that relate to an understanding of the family and the dynamics, et cetera, but that person doesn't have the sort of business judgment, the sort of acumen for practical things, and maybe you'll want to say, fine, I'll have somebody who will be in charge more of the asset decisions, and someone else who will be charged with more of the distribution decisions, payouts to beneficiaries. There's always you can divide that up, and you can have these specific roles, which is the wonderful thing about this thing we're talking about, this box, is that when you're deciding who's going to run it, who's going to follow the instructions, you have a lot of options.
Yeah, I tell our clients very often, if you think it can think it up, I can write it.
Yeah, there's lots of room for creativity. And let's move on, though. And some of the principles we talked about will apply to beneficiaries, too, about the opportunity to have successor beneficiaries, et cetera. So talk a little bit about beneficiaries.
The beneficiary, when we talked originally about settlor, trustees, and beneficiary being the three main characters in the trust, when you first create that agreement with yourself, you're all three, right? You're the settlor, you're the trustee, you're the beneficiary. Your settlor powers are unique to you. If you were to pass away, no one else is going to become the settlor. No one's going to step into that position. If you're no longer able to act as trustee, there will be a successor. And similarly, with a beneficiary, if you're no longer here to receive the benefit of the trust, the people you named in the document will then step into your role as receiving the benefits.
And that's worth pausing on. I want to be sure that idea makes sense. When we talked about these three roles, they all reside typically in the same person when the trust is created. So it may seem odd to you, but you can actually be the person who creates your trust. You can name yourself the person who's in charge of it, and you can name yourself as the only beneficiary of the trust while you're alive. So really, you're running everything. You didn't create it to be that way. You just knew that you didn't need to transfer that authority now. So this is a way of creating this machinery and having everything in place perfectly so that when the moment comes, and you never know when that moment is, meaning you could be driving down the road after creating this trust, it could be a month later and you have a car wreck. Suddenly you're rendered incompetent or unconscious or, something that means you can't run things. The wonderful thing then is that automatically these roles break out, meaning that you're still the beneficiary, you're the only beneficiary, because as long as you're alive, you're that. And then you're still, of course, the settlor, the person who created it. But now someone else will be the trustee, but the trustee's job will be to run what you created for you while you're alive. And that's when it would happen automatically. No judges, no delay, no expense associated with that. I mean, it's a marvelous tool that is in place to take care of you the moment you need it, a moment that you have no idea when it's going to be really. It could be decades. It could be much sooner.
And separating out those roles, I'll talk to people about incapacity versus their passing, right? And when we're talking about successor trustees and who's going to take over when you're no longer here, well, they may choose a different set of people for managing the property for the benefit of the beneficiaries. And when I say to them, oh, do you want that bank managing your trust while you're incapacitated? Oh, no, I don't want to deal with a bank in relation to my property. And so you can name different trustees for when you're incapacitated as opposed to when you're no longer here, because you might want different people for that. And I think this is also a good place to say the distinction between a trust and a will is that when you create a trust, that entity is created the moment you sign the document, right? With the will, you're creating a list of instructions for the probate court, okay? And the probate court has a whole process for proving that will is actually valid, okay? And when you create a will, it's not created until the moment the court gives it its stamp of approval. So what you were talking about as far as incapacity wouldn't be applicable to a will because until that probate court says it's valid, it's just a piece of paper.
Yeah. I want to come back to that. So I want to finish fleshing this out, though, with the beneficiary. You may have the idea that you simply want, when you pass away, for things to be just handed to your beneficiaries immediately, and that you don't want a trustee to be in place to manage those over time. And that's okay. The trust saves you an immense amount of money, an immense amount of delay, an immense amount of time. It has all these wonderful benefits if you do nothing more then have the job of the successor trustee or the same trustee to go ahead and hand out the resources to your various beneficiaries according to your instructions. That's perfectly fine. But I think that for most people, that's an unfortunate waste of the power and potential of a trust. You can, for those who have a significant estate, I'm not talking Rockefeller estate, I'm talking $500,000 or more, which we, according to statistics, is like the wealth of many homeowners now. And if you throw in 401ks and other assets, then you're easily above that number for many of you. It suddenly makes sense to have a means to give that to your children in a way that allows them to have asset protection, to allow them to have certain advantages in terms of control and risk, to avoid the problem so often happens in divorce, where things that are inherited become marital assets. They do, because the care it takes for someone to manage their assets in a way to keep them separate, and it is possible, incidentally. But I can just tell you, as a domestic relations lawyer, former domestic relations lawyer, and estate planning lawyer, I can tell you that in marriages, probably 1 in 20 or 30 succeed in fully protecting inherited assets in a marriage. Mm-hmm. It's just, it ends up going into an account where other money's thrown in. It gets commingled. That in many states can cause the whole thing to become a marital asset because it's inseparable. So there are just so many pitfalls, not to mention lawsuits, bankruptcy, things that happen to good people, to even good businessmen and women sometimes have businesses fail. And that can cost them everything they own. But the wonderful thing about this trust is you have locked up and protected from all those predators the assets that you leave for your children. And yet you can do it in a way that they can pretty much have what they need when they want it. These instructions that John just talked about, those instructions can be very permissive. They don't have to be, this authoritarian set of rules. This can be a set of rules that essentially lets the trustee be very flexible to give you what you want. But the point is, once your children understand the value of leaving it in the trust, they're not going to want to take out more than they need. So it's just a marvelous, marvelous gift that you give them, that if you just pay out the money immediately, you've not given them as good a gift. I mean, do you want to give them the best gift? Well, the best gift is something that's far more valuable and that they're incapable of creating themselves. They can't take that money, and John, you talk about this. Let's assume they inherit $1 million. Mm-hmm. Can they go down the street and buy themselves that asset protection, create their own trust in a way that would do that?
Not in the same way they can when they inherit it. And what your distinction you're making here is between a revocable and an irrevocable trust. And that's a term, when you're looking at this online, you're going to come across this very often and maybe be confused by the way it's described. But when you create these trusts with us, these are revocable trusts, which means you have 100% of control. If you want to take stuff in and out of the box, if you want to change the instructions on the lid, if you decide someday to tear up the box and get rid of the whole thing, that's your prerogative, right? Yeah. But the moment that settlor passes away, that one with the unique power to do what I just said.
You.
Yes, yeah.
The moment you pass away or become incompetent, right?
Yeah. That box gets a lock on it because nobody's able to change things except you, right? And you'd think that lock would be restrictive, but it's freeing in the sense that it becomes asset protected, because now those terms that you've written on the lid, nobody can change those. And the beneficiaries can benefit from the property that's in there, but only upon the terms that the trustee administers it and that you've left. And that's where the asset protection comes in. They're still the main beneficiary. All of it can be used for them based upon what you said. Is it for education, being a big one people are concerned about, right? Medical bills, all the other kinds of things that can pop on us. Let's call it needs versus wants, right? And the moment that you've passed, this trust becomes irrevocable, and all of that property in there is protected. And the trustee can administer it and help your children with the life they need, but not give them more than they need at that point.
Yeah. And the smarter your children are, For example, if you have a child that's an attorney and a CPA, I'm willing to bet that assuming they know anything about this subject we're talking about, and you say to them, look, I can give you $1 million through a trust in the way we just described, or I can just give you $1 million cash. What do you want? Well, I can tell you if your child's an attorney or CPA or in some other way really informed about this subject, they're going to say, no, give it to me in the box. Give it to me in the box, and that way I'll be able to access what I really need, and yet I'll have all these incredible protections that I couldn't otherwise have. Mm-hmm. So I dwell on this subject a lot in the show, but to me it's so exciting that I try to dispel the notion that somehow it's handcuffs or trying to rule from the grave. I've heard clients say that. I don't want to control my kids from the grave. Incidentally, some kids you should try to control. I mean, there are those kids, but let's assume your kids are perfectly well-adjusted, marvelous, successful kids. My argument is those kids, if they don't know, should know that it's so much better for them if you do this in the form of this box we're describing. And there they have their cake and it's close to having your cake and eating it too.
Especially if they become the trustee at some point, right? And under Missouri law, with our Missouri Asset Protection Trust, you can be the trustee and a beneficiary of this inherited trust and still have a certain level of creditor protection as long as you follow the rules left by the settlor. Yes,
this is a good point. I'm not as surgical in trying to walk that line. So I often, err toward just, not having the trustee and the beneficiary in the scenario I'm just describing, we're talking about here, be the same person. But John's right. It can be, you can sculpt that language to where it allows your child to be the trustee and to be the beneficiary and have all these, if not all of them, most of these benefits I just described. So even that could be done. But I just think that that there are so many good reasons to do it this way, and all too many people have this misunderstanding that you only do that when you think your kids have drug problems or they're dishonest or something, or they have some, psychiatric or develop some issue like that. No.
Yeah, and those are good times to do it, but it's not the only time for sure.
Well, you're right. That is a reason to do it.
Right.
Yeah.
And a lot of times I'll say to the parents, I'll say, they're going to blame you for what goes wrong anyway. They've been doing it your whole life, right? So why not give them the grace of doing what's best for them in this last act?
That's right.
Putting it in that trust and maybe for the first, whatever that age is, up to 35, 40, 45, it is managed by somebody else, right? And then you can let them at some point take over, rather than having the money distribute and have it potentially available to creditors or divorce or all the things you talked about. They could keep it in there and have that choice, right? If they've become wise enough at that point to realize the benefits that you've been talking about here, they can, instead of withdrawing the money and making it susceptible to creditors, they can leave it in there and become trustee and get that benefit.
Yeah, and we should go to the next level too. Now, at one time, what we call dynasty trusts, which doesn't mean necessarily that you're a Pierpont Morgan or you're the DuPonts. At one time, that's kind of what it meant. And so the law had this thing called the rule against perpetuities, which was intended to prevent dynastic wealth from being locked up, for an infinite period of time. Mm-hmm. It just forbade that. So it was a very complicated rule that essentially said that beyond, somebody alive now plus a certain number of years, the trust had to conclude. So that changed couple decades ago.
It's state specific, but in Missouri, we got rid of it a while back in the statutes.
Yeah, so that's called the rule against perpetuities. And so it's pretty recent, this phenomenon where you, regardless of how much you're worth, you want to have enough money to justify the administrative cost and hassle, which doesn't have to be great, but it'd be a little bit. So it wouldn't apply to all of you, but people who have, I'll go as low as $500,000 because this money, if it's left alone, is going to grow and it's going to compound. So you can't really judge it based on the number you have now. but I would feel safe saying the dollars definitely make sense in terms of cost to benefit if you have $500,000, and that would include money going into it from life insurance and other sources. But if you're going to have a pot of that size, which I know many of you will if you don't already now, then you should be aware that there's a very probable, even certainly conceivable scenario in which, and I bet you've had clients who've done this. You have a child who marries, and they're both professionals. Husband and wife are professionals. They're making good money, and yes, it'd be nice to get the money that you're going to leave them, but they're doing fine, and they have 2 or 3 kids, or they're going to have kids. I can tell you what we're seeing commonly happens in that scenario is because we created this trust in the way we just described it, and it's discretionary, meaning the trustee can choose to pay it out or not, and the trustee is going to get feedback from the beneficiary as to whether it should be paid out or a request. So often children such as that, say they're both professionals, they're going to take the position that, wait, so I can leave this alone and I can give this to my kids, and they're going to get this pot of money that's going to be similarly protected. So their thinking is, well, if I need it, I'll take it out, but I don't think I'm going to need it in my lifetime. So I'm going to leave it there, and then if it's still there when I go, then we will leave it to our children. Well, the trust permits that. It can go into multiple generations. Mm-hmm. And these are really great benefits. Now, you probably have them for tax reasons pay out like the income each year.
Right. Depending upon what your intent is here, right? Yeah. And I should probably go back, and you're bringing up a good point here. I said there's 3 characters whenever you create a trust: the settlor, the trustee, and the beneficiary. Well, there's always a 4th in the room that we forget about, and that's Uncle Sam. Right? Yeah. Because they're going to want their tax money, right? And you were talking earlier about those dynasty trusts, and a lot of the reason that those were created originally was to kind of hide money so that property could pass from generation to generation without getting taxed, right? Mm-hmm. Well, of course, over a period of time, the IRS figures out, wait a minute, we're not taxing this as it's passing from generation to generation. And going back and maybe aging myself a little bit here, we used to talk about radar detectors in your car, right? And every time the cops came up with
radar detectors,
I don't know. I was wondering the same thing the other day. Every time the cops come up with a better radar detector, a better fuzzbuster, we come up with a better
fuzzbuster.
That's what they call it.
Now that's a phrase I bet you haven't heard in a while.
And so it's kind of the same way with these trusts. As attorneys get creative and find new ways to bend the rules to try and advantage our clients, the IRS will figure out ways to bend it back, right? And that's why a lot of these rules against perpetuities are starting to go away, because the IRS has a lot of tools for bending it back. You know, the generation skipping tax. So instead of, if you pass something to your grandkids, instead of maybe just being taxed once like you would have if you passed it to your child, if they're 37 and a half years younger than you or your actual grandchild, it'll get double taxed, right?
Yeah.
And so we figured out ways in these trusts to let them live for longer than they used to before, but also to handle these taxing situations at multiple generations.
Yeah. Yeah. And so there are ways to where you can do this and take advantage of exemptions that exist today that are very favorable, and they're not likely to go away for a while.
Yeah, we're up to $15 million starting next year, right? Yeah. The big, beautiful bill gave us that. So we're guaranteed, I think, for at least 3 years, because the guy in office has a personal interest in making sure that this is a high number, right?
Yeah, right. He definitely, and his family. But there, I think the generation skipping exemption was what, $1 million, or it was lower?
It's the same as whatever the general exemption is. So you can do that.
You can use your $15 million for that.
Yes. Yeah.
Okay. Mm-hmm. Very good. So I think it's important then to think about a trust not as this great complicated piece of machinery. We've tried to make this very simple for you. And while we threw in a little complexities there in the discussion, just for some of you that might have an interest, for many of you, these tax implications won't be relevant. And for you, it's a practical consideration about achieving things for your children. Anyway, we will be back with our next episode to continue working through this 8-point list of the most commonly asked questions on YouTube about estate planning. Till next time, take care.
We hope you enjoyed Life's Third Act, sponsored by Cordell Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.